Hello everyone, we are the Group 3 of BSA 2A and we will now present and explain to you the Title 13, Chapter 3 of the Revised Corporation Code of the Philippines, titled One Person Corporation. Section 115 talks about how Title 13 of this code applies to one-person corporations, or OPC for short. An OPC is a corporation with a single stockholders. It says that the Title 13 applies to one-person corporations. However, when there is something that is not covered by Title 13, the general provisions of the Revised Corporation Code of the Philippines will serve as a backup. Section 116 explains what a one-person corporation or OPC is and who can set up one. An OPC is a corporation with a single stockholder. Only individuals of legal age, trust, or estate can create an OPC. Moreover, certain types of corporations, like those that are vested with public interest, cannot set up an OPC. Licensed professionals are also not allowed to set up an OPC unless a special law says otherwise. If the stockholders of an OPC is acting on behalf of someone else, like a trustee or a guardian, they need to provide documents proving that they have the authority to do so. Foreigners can also create an OPC, as long as they follow rules about capital and investment limits in specific industries. Normally, the life of an OPC is perpetual. But if it is based on a trust or an estate, it will only last as long as the trust or the estate exists. Section 117 says that one-person corporations doesn't need a minimum amount of authorized capital stock. This makes it easier and more affordable to set up an OPC. However, if there is a special law for a specific type of corporations, such as pawn shops and insurance companies, that law might require a minimum amount of capital stock. Section 118 explains the extra information needed when creating the articles of incorporation for a one-person corporation. If an OPC is owned by a trust or an estate, the details of the person managing it must be included, along with the proof that they have the authority to act for the trust or the estate. Additionally, the articles must list a nominee and an alternate nominee who will take over if the stockholder can't run the OPC. Their details, along with the limits of their authority, must also be included.
In Section 119, which is all about the bylaws, it is stated that one-person corporation is not required to file or submit corporate bylaws. It is because the revised corporation code created the one-person corporation so that people can easily enter or engage in the corporations. In Section 120, which is all about the display of corporate name, it is stated that one-person corporation shall indicate the letters OPC either at the end or below its corporate name. It is for the public or for the people to easily distinguish that the corporation is a one-person corporation. Section 121, which is all about the single stockholder as the director and the president. The single stockholder shall be the sole director and president of the one-person corporation. It is because he has complete control over the corporation and he does not need any approval from other stockholders.
This is Section 122, Treasurer, Corporate Secretary, and other officers. Within 15 days from the issuance of the Certificate of Incorporation, the one-person corporation shall appoint a Treasurer, Corporate Secretary, and other officers, as it may deem necessary, and notify the Commission thereof within 5 days from the appointment. The single stockholder may not be appointed as the corporate secretary. A single stockholder who is likewise the self-appointed treasurer of the corporation shall give a bond to the Commission in such a sum as may be required, provided that the said stockholders or treasurer shall undertake in writing to faithfully administer the one-person corporation funds to be received as treasurer, and to disburse and invest the same according to the Articles of Incorporation as approved by the Commission. The bond shall be renewed every 2 years or as often may be required. Take note, within 15 days from the issuance of the Certificate of Incorporation, the one-person corporation shall appoint treasurer, corporate secretary, and other officers, as it may deem necessary, and notify the Commission thereof within 5 days from the issuance. Also take note, the single stockholder may not be appointed as the corporate secretary, but may assume the role of a treasurer. The single stockholder who assume the position of the treasurer shall post a surety bond. This is section 123, a special function of the corporate secretary. In addition to the function designated by the one-person corporation, the corporate secretary shall be, number 1, be responsible for the maintaining the minutes, book, and or the records of the corporation. Number 2, notify the nominee or alternate nominee of the death or incapacity of the single stockholders, which notice shall be given no later than 5 days from such occurrence. Number 3, notify the Commission of the death of the single stockholders within 5 days from such occurrence, and stating in such notice the names, residence address, and contact details of all legal heirs. And lastly, call the nominee or alternate nominee and known legal heirs to a meeting and advise the legal heirs with regard to, among others, the election of the new director, amendments of the article of the incorporation, and other ancillary and or constitutional matters. So that's the 4 special features of the corporate secretary, and that feature is the addition to the function designated by the one-person corporation. Take note, the one-person corporation can designate other function to the corporate secretary. Section 124. Nominee and alternate nominee. The single stockholder shall designate a nominee and alternate nominee who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholders as director and shall manage the corporation affairs. The article of incorporation shall state the name, residence addresses, and contact details of nominee and alternate nominee, as well as the extent and limitation of their authority in managing the affairs of the one-person corporation. The written consent of the nominee and alternate nominee shall be attached to the application for incorporation. Such consent may be withdrawn in writing anytime before the death or incapacity of the single stockholder. Take note, the single stockholder is required to designate a nominee and alternate nominee named in the Articles of Incorporation, who shall replace the single stockholders in the event of death or incapacity. The single stockholders and nominee and alternate nominee shall take the place of the single stockholders as director and shall manage the corporation affairs. Also take note, the written consent of both nominee and alternate nominee shall be attached to the application for incorporation. Such consent may be withdrawn in writing any time before the death or incapacity of the single stockholder.
The section 125 covers about the term of nominees and alternate nominees. The term of nominees and alternate nominees depends on different situations. When the single stockholder is temporarily incapacitated, meaning the single stockholder is temporarily unable to perform their duties due to illness or other temporary reasons, the nominee will take over and will act as a director and manage the OPC's affairs until the owner regains the ability to resume their operations and responsibilities. In case of death or permanent incapacity, if the stockholder passes away or becomes permanently incapacitated, the nominee again steps in as director and manager. However, this is only until the legal heirs of the stockholder are identified. Once the heirs are lawfully determined, they must decide among themselves who will take over as the new single stockholder, or they can agree that the estate will hold ownership of the OPC. Role of the alternate nominee. The alternate nominee comes into play if the primary nominee cannot fulfill their duties, whether due to incapacity, death, refusal, or inability. The alternate nominee will step in under the same terms and conditions as the primary nominee. Section 126 allows a single stockholder to change the nominee or alternate nominee at any time. There is no restriction or special timing required for making this change. It's entirely at the direction of the stockholder. The process is straightforward. The single stockholder simply needs to submit the name of the new nominee and or alternate nominee to the Securities and Exchange Commissions. Along with this, the new nominees must provide their written consent to serve in their roles. So here's the catch. Making this change does not require amending the Articles of Incorporation. This makes the process faster, easier, and less costly for the OPC, as amending the articles usually involves more formalities and fees. Before we start to discuss this section, which is section 127, let us first define what is a minute of book. A minute of book is a formal record where all important decisions, actions, and resolutions made by the corporation are documented. In the case of one-person corporation, maintaining a minute of book is a legal requirement. The minutes of book serve as the official record of everything that happens in the OPC regarding its management and decision-making. It ensures accountability and transparency by documenting every action, decision, and resolution of the single stockholder or their representative. Since the OPC has only one stockholder, they are responsible for maintaining these minutes of book. It reflects the actions of the stockholder in their capacity as both owner and manager of the corporation. Every action taken by the stockholder, such as operational changes, approvals, or financial decisions. All decisions related to the management of the business, such as hiring key personnel, entering contracts, or adopting policies. Any resolution passed, such as declaring dividends, appointing a new nominee or alternate nominee, or other significant corporate resolutions. The minutes of book is a legal document that can be used as evidence of corporate decisions. In summary, Section 127 emphasizes that an OPC must maintain a minutes of book to document all significant corporate actions, decisions, and resolutions. This helps ensure transparency, accountability, and legal compliance for the OPC's operations. Section 128 talks about the records in lieu of meetings. Unlike regular corporations that require board meetings or stockholder meetings to make decisions, a one-person corporation has a simple process. Since OPC has only one stockholder, meetings are not required. Instead, all actions and decisions can be made through a written resolution. In an OPC, if any action or decision is required, the single stockholder does not need to convene a formal meeting. Instead, the stockholder can simply prepare a written resolution stating the action or decision. The resolution must be signed and dated by the single stockholder to confirm their approval and authority. This resolution must then be recorded in the minutes of book of the OPC. The date when the resolution is recorded in the minutes of book is considered the official date of the meeting for the legal purposes. These provisions ensures that the OPC complies with legal requirements, even without the need for formal meetings. This process saves time and effort, making it easier for the single stockholder to manage the OPC. It also maintains proper documentation and accountability without the need for unnecessary formalities. So why is this section important? This section provides flexibility and efficiency for the OPC. It allows the single stockholder to make quick decisions without being bogged down by procedural requirements while still ensuring that the actions are properly documented and legally valid.
Section 129, Reportorial Requirements, states that the one-person corporation shall submit the following within such period as the Commission may prescribe. First, annual financial statement audited by an independent certified public accountant, provided that if the total asset or the total liabilities of the corporation are less than 600,000 pesos. The financial statement shall be certified under oath by the corporation's treasurer and president. Second, a report containing explanation or comments by the president on every qualification, reservation, remark, or disclaimer made by the auditor in the latter's report. Third, a disclosure of all self-dealings and related party transactions entered into between the one-person corporation and the single stockholder. And fourth, other reports as the Commission may require. For the purposes of this provision, the fiscal year of a one-person corporation shall be that set forth in its article of incorporation, or in the absence of thereof, the calendar year. The Commission may place the corporation under delinquent status should the corporation fail to submit the reportorial requirements 3 times consecutively or intermittently within a period of 5 years. As the owner of an OPC, you are legally required to submit reports to the SEC to ensure transparency and compliance. First, the financial statements. This must be audited unless your company's assets or liabilities are below 600,000 pesos, in which case you can simply certify the report yourself. Second, auditor's remark. If an auditor highlights issues with your finances, you need to provide a written explanation. Next is self-dealing transaction. Any personal dealings with the company must be disclosed, such as renting your own property to the OPC. Next is the other reports. The SEC can ask for additional documents. Failing to submit these reports 3 times in 5 years can lead to penalties, including being marked delinquent. Section 130, Liability of Single Shareholder, state that a sole shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. Where the single stockholders cannot prove that the property of the one-person corporation is independent of the stockholder's personal property, the stockholders shall be jointly and severally liable for the debts and others' liability of the one-person corporation. The principle of appraising the corporate bill applies with equal force to one-person corporation as with other corporations. You usually aren't personally responsible for your company's debts, but this protection or limited liability only applies if, first, you prove that your company had enough funding to run properly. Second, you keep your personal assets separate from your business asset. If you fail to meet this condition, creditors can go after your personal belongings. Additionally, if the OPC is structured to avoid responsibilities, the law can still hold you personal liable. This is called piercing the corporate veil. Section 131, Conversion from an ordinary corporation to a one-person corporation, state that when a single stockholder acquires all the stocks of an ordinary stocks corporation, the latter may apply for conversion into a one-person corporation, subject to the submission of such documents as the Commission may require. If the application for conversion is approved, the Commission shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. The one-person corporation converted from on ordinary stock corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. If you buy all the shares of a regular corporation, make you the sole owner, you can convert it into a OPC by filing the necessary paperwork with the SEC. Once approved, your new OPC inherits all the responsibilities and debts of the original corporation. Section 132, Conversion from a one-person corporation to an ordinary stock corporation. A one-person corporation may be converted into an ordinary stock corporation after due notice to the commission of such fact and of the circumstances leading to the conversion, and after compliance with all other requirements for stock corporation under the code and applicable rules. Such notice shall be filed with the commission within 60 days from the occurrences of the circumstances leading to a conversion into an ordinary stock corporation. If all requirements have been complied with, the Commission shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. In case of death of the single stockholders, the nominee or alternate nominee shall transfer the shares to the duly designated legal heir or estate within 7 days from receipt of either an affidavit of heirship or self-adjudication executed by a sole heir or any other legal document declaring the legal heirs of the single stockholders and notify the Commission of the transfer. Within 60 days from the transfer of the shares, the legal heirs shall notify the Commission of their decision to either wind up and dissolve the one-person corporation or convert it into an ordinary stock corporation. The ordinary stock corporation converted from a one-person corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as a date of conversion. If your OPC adds new shareholders, you can convert it back into a regular corporation by notifying the SEC within 60 days and meeting all the legal requirements. If the single owner of the OPC passes away, the nominee or the backup of person must transfer the shares to the legal heir within 7 days. The heirs then have 60 days to decide either close the OPC or to convert it into a regular corporation. In both cases, the new corporation will inherit the debt and obligation of the OPC.